Hi there, good afternoon and welcome to today's DPS guest webinar with Susie Proler, the Managing Director of the Guild and Letting and Management. How are you doing, Susie? Okay?
Yes, I'm very well, thank you. Looking forward to this session.
Should be a fantastic session. This is a Q&A session today. I'm David Hackett, Head of Client Management here at the DPS. This is a guest webinar, so the information provided will be supplied by the Guild and we'll give you more information, but the Guild of Letting and Management rather, will give you more information on how to access that at the end. You will have seen, and we've already started to see some questions come in already, that this is a live Q&A session webinar. However, I will caveat that by saying today's topic is local authority enforcement powers. So as we go through the session today with Susie, questions relevant to this topic, we'll get those set up on the screen and ask those at the end of the session. For general questions surrounding the Renters' Rights Act, I'm sure many of you have seen already, we did a general Renters' Rights Act webinar not too long ago with Susie. So if you have any questions relating to it generally, you can go and have a look at that, which is available on demand. Or alternatively, my advice would be to continue watching the rest of this series of webinars. There'll be 5 of them in total, so we'll get adverts out and sign up for all of those as and when they happen. So without further ado, I shall pass over to you, Susie.
Thank you, David. So as David said, the topic for today's session is obviously the Renters' Rights Act, but local authority powers that the local authorities in England were granted on the 27th of December 2025. So that's, almost 3 months ago. Very, very important that we are going to examine how and when these powers could be exercised and where that leaves landlords and obviously letting agents. So, as I said, these powers are already in force, and in the work that we do, we've already been having discussions with landlords and letting agents that have started to see the effect of the investigatory powers from local authorities, not just, I hasten to add, in London, but across the whole of England. So before we look at the detail, there's some things that the local authority themselves need to be sure of. They must be sure that the powers are only used where legislative provisions allow and are in force. Okay, so what I've done is I've broken the actual legislation itself is quite vast. So I've broken it down into some manageable elements for us to navigate and discuss. So the first thing is that local authorities can request information. The second is that a local authority in question can enter a business premises. And when I make reference to business premises, that could be the offices of property management team, it could be the offices of a letting agent. They can also inspect and seize documents, and they can enter residential premises that are currently being let, but only where certain conditions prevail and where they believe that there is a suspicion that there is a breach of housing law. The powers to request information sit under a whole range of legislation. So right at the very top, we've got a piece of legislation that's been around quite a long time, Protection from Eviction Act, to make sure that the tenant has been able to enjoy the quiet enjoyment of the property, relevant notices are served, that the tenant has not been harassed, unlawfully evicted, or is in the process of being unlawfully evicted, and so on. Housing Act 88, again, has been around a while, and that is probably for the majority of us that have been in the industry, probably since that point and up until now, our go-to piece of legislation for so many elements relating to assured and assured short hold tenancies. Enterprise and Regulatory Reform Act, Housing and Planning Act, and then almost at the bottom, something that you've become very familiar with is the Renters' Rights Act, followed by the Housing Act 2004. So there's only one of those pieces of legislation that actually isn't currently in force, and that's obviously the Renters' Rights Act. So these powers that the local authorities in England have been given should relate to an element or a possible potential breach of any one of those or more pieces of legislation. So before we go on to look at the powers themselves, there are, when legislation is drafted, a lot of definitions, and within the Renters' Rights Act, there's some new terminology that we have to get used to. What you see on screen is not new. We've seen this before under the Housing Act 2004 and also under the Tenant Fees Act 2019. So a relevant person is defined under the Renters' Rights Act as anyone who has, and they have put a time frame in place, had an interest or has an interest in land. So that would be the premises that we're dealing with, and that could be a flat, has to be residential, obviously, a house, an apartment, a bungalow, and so on. This relevant person has been a licensor. The relevant person could have purely marketed the property but does not manage the property. So that's extremely important. And then specifically, but not limited to, for letting agents and property managers and other property professionals, those that have acted for or stated that they act for someone who has an interest in the land, estate, premises. Okay, so therefore, letting agent is and could be a relevant person. So that needs to be defined. That relevant person needs to be identified. Okay, so hopefully the local authority will deal with the correct relevant person. So on top of dealing with the relevant person, we need to think about what is a rental sector business. And for the majority of us, we have a very good understanding. When we see the word business, we don't automatically think about landlords. Okay, I think that that's one of the misconceptions within the sector, is that landlords aren't actually running a business, but in fact we know that they are. So effectively, a landlord who's running a property portfolio, maybe they have 3 properties, maybe they have 300 properties, effectively would be defined under this category as a rental sector business. Our obvious go-to would be a letting agency that deals with residential accommodation. That letting agency could also create licenses to occupy. They could purely market the property, but not manage. So that's really important. And obviously they could be the agent that not only markets, advertises, finds the tenant, but also manages the property either under a tenancy or a license to occupy. Okay, so we have 2 definitions there. We're thinking about who the relevant person is, and automatically we might think about the landlord, we might think about the letting agent, and what is the definition of a rental sector business. And those 2 key points are very important when the local authority is dealing with enforcement and these new powers that they have been granted. So just to make things easier, I've split the 2 key elements into 2 parts, okay? Because I really want you to think very carefully about the difference between part 1 and part 2. Okay, and I've even put in some questions that we can think about. So part 1, and this is the way that I've written this, if you look at the legislation, it won't make reference to Part 1. So this is the way that I've put things together for ease. So Part 1 is that the local authority has the power to request information. Okay, now under this part of the legislation, this request must be made in writing. It must be addressed to the relevant person, so that, just again for ease, landlord or letting agent from whom they require the information. The request, and I stress this is very important, being made in writing will be signed by a local authority housing officer. Now, not because I am lacking trust or faith. If you receive a request like this in writing, and it'll either be sent to you via email or by post, you check that it's valid. Okay, you do some research on the local authority, check that the housing officer exists, and make sure that you've done your due diligence. Okay, because there's a lot of scams out there, so we want to make sure that we are dealing with a genuine request. The notice will be made, and this is a written notice, will be made under section 114 of the Renters' Rights Act, and it will give you an indication of certain things that must happen. The first thing that must happen is the request must be made in writing, and I keep reiterating that because I've seen examples of this already, and it's a very in-depth request. Okay, so it will be in writing. The second is that the local authority must tell you what the possible consequences are of not giving the information. Okay, so they will advise you, usually towards the end of the document, what happens if you do not provide the information. The third thing, and this is quite crucial, is that they will tell you that you must adhere to the request within a certain time frame. Now, I've given you 2 examples, and it could be anything in between. It could be that you must provide the information within 7 days of the request being made. Okay, so that's quite short. Okay, it's important to bear in mind, you look at the time frames, I think 7 days, and it's 7 days, calendar days, not 7 working days. Or it could be 28 days, but it could be 14 or it could be 21. So pay attention to that information. If ever, I'm never saying never, if you ever receive a written request for information. They will also tell you within that document how you must submit this information. So 2 formats. It will either be hard copy, so that would tell you that you make copies of the originals. I stress here, do not send originals. You'll make copies of the originals, and then you will bundle them up, and then you will send that information by post, and preferably a method that allows you to track that the bundle of information has arrived. So that's the first option. The second option is digital. Okay, so this information will be in this document that you receive, asking you to submit information under section 114 of the Renters' Rights Act. So what type of information can be requested? Now, before I look at this, I want to tell you the type of information you should not be sending. You should not be sending information that is data sensitive. You should not be sending information relating to the tenant's referencing history. You should not be sending details relating to contractors that you use. So there could be a process whereby you would have to redact information. Okay, and we're very much used to that. If any of you have ever experienced a subject access request under data protection. Okay, so we do not breach confidentiality. We need to be very clear that the information requested should only relate to an investigation. Okay, so that's really important. So if we get back to the type of information that can be requested, I've given you a scenario. And this scenario relates to an investigation that relates to a suspicion that the landlord is in breach of HMO licensing. Okay, it could be that the landlord has obtained a license, but has not fulfilled the conditions of said license. Okay, so everything will be set out very, very clearly, because obviously we want to know, why do they want this information? So the local authority could request, and I've just given you an overview, but this is not an exhaustive list, all the tenancy agreements related to that particular property. Gas safety certificates, EICRs, EPCs, how to rent guides that were issued from the beginning of the tenancy and then right the way through renewals or whenever there was an update, copy of the HMO license application, proof of payment, chronology of maintenance and repairs, because they may be looking at an issue in relation to conditions that have not been dealt with that relate to maintenance, and then any notices served, and it could be section 13, section 21, section 8. Okay, but remember, this is not an exhaustive list. They could also ask for information relating to tenancy deposit protection, the deposit certificate, the prescribed information, and so on. Okay, so if you ever receive a letter like this from the local authority, after you've done your own checking and your own due diligence, you should take legal advice. Why? Because you want to be sure that you are adhering to a request that could potentially result in penalties for non-compliance. So you should check very carefully. And this is the experience that we've had at the Guild. We've had clients who've received a request for information, and they always check with us and make sure that this is what they're meant to be adhering to. And I can quite happily and very easily say that, yes, you must adhere to this. Okay, so that's the first element. So can this request for information be refused? Now, in short, the answer is yes. Would I advise that? I'm not going to give anybody legal advice, but this yes could be followed by why. Why would somebody refuse to provide that information? Now, I've mentioned already that the time frame could be as short, as brief as 7 days. And you might be thinking, or a landlord or a letting agent or a property manager, they're thinking that time frame is too short. I'm not going to send that information. Now, although we might think that that time frame is unreasonable and unrealistic, we should be requesting from day one an extension. Okay, so that is not a reasonable reason to refuse. Bullet point 2, the landlord no longer owns the property. Okay, so it could be that the landlord's sold and is no longer involved, but be very careful. This could be relating to a pre-existing landlord. Okay, so the landlord might be thinking, well, I don't need to reply to this because I'm no longer the owner, but it could be related to a period prior to them selling. Okay, so that's very important. The agent does not manage the property. Now, that's quite a pertinent point. The agent might think, I don't manage this property. I only marketed, advertised, found the tenant. That does not negate responsibility. So it could be that the local authority is interested in what happened pre the landlord taking over management. Okay, so they're interested in the element relating to tenant find, not necessarily management. Okay, so again, that might not be a reasonable reason to refuse. This is very important though. The request made does not comply with section 114. So you need to check really carefully, and I've given you a list right at the very beginning that this request fits under those key elements of legislation. And you might think, this doesn't fit in with what I'm aware of. Okay, so obviously you take legal advice, you'll be guided, and then you go back to local authority and say, why have you requested this information? Because it doesn't fit in with the criteria that you as a local authority must abide by. Okay, so it's not just as simple as saying yes or no. Read the information that they send you. So, consequences of refusing. So I've said that potentially somebody could say, no, I'm not providing the information. However, often when we deal with this during a training session, the response to consequences is often a penalty or a fine. Well, not in this case, because they haven't got anything to fine the letting agent or the landlord for. What they do have in their power is they can apply to the courts and request a court order and force the relevant person to provide that information. Okay, so they will speak to the judge, make their request, explain why, and the likelihood, and I'm never going to say never, is that they will be granted a court order. Now, how does that impact the relevant person? Well, the fact is that they'll be forced to provide the information under this court order. So this, they are compelled to do so. But on top of that, the burden is that the landlord or the letting agent or the property professional will have to pay for the costs that are incurred by the local authority to apply for the court order. Okay, so understand how serious this is. People often say, well, how quickly can the local authority get a court order given the backlog in the courts for everything that we can think of? I stress very quickly. Okay, so do not be in that position. If you receive a request for information in writing, do your due diligence. Check very, very carefully what they're asking for and why, and then get legal advice. Okay, so you can do all of that within 24 hours of receiving this request. Now, so that's part one. Part one effectively is a written notice. I'm not going to call it a written warning because it isn't, but they're giving you time. The local authority is giving you time to pull together the information that they need and then send it to them. Okay, so you may think that's quite stressful. This second part is probably much more stressful. So this power that the local authorities in England have been given is very unusual. This allows the local authority to enter a rental business and or a residential premises without warning and without a warrant. Now, I know on screen it says with a warrant, but that should refer to what we've just talked about. So they can enter a business premises, and let's just say, for example, it's a letting agency in Hertfordshire. They will attend during reasonable hours, and we'll just say that the agency opens at 9 and they finish their business working day at 5:30. So any time between those times. They can immediately on site, request information, documents, all of those documents that I've already talked about, but they can also seize evidence, okay? If they believe, and they will know because a letting agency, generally on the high street, is it a rental sector business? Yes, it is. Is it run by a relevant person? Yes, it is. Why? Because they generally represent and act for landlords. Okay, so that fulfills the criteria. Is there going to be a warning? I really want to stress here that they do not need to write to you. They do not need to phone you. They do not need to email you. They do not need to put anything in writing. They can just turn up, okay? And this is them exercising the power of entry. And as I said, this is very unusual. Probably the closest we have to this is trading standards, who can go into businesses, but generally there'll be some sort of forewarning. Here there is no warning. What can they do? The local authority can bring another person or people with them who will have the same powers. They can seize equipment, computers, information, data. They can take photographs, make recordings, and so on. So this is extremely serious. Now, I'm not going to say it's unusual. Since the 27th of December, 2025, I've not had a discussion with any of our clients, landlords, or letting agents that have experienced this. I've seen an information request in writing, but not yet a visit. And I'm not going to say it's going to happen. Okay, so that's very important. Some local authorities may be quite gentle, and they might give you a written warning and say, we're coming to your premises tomorrow. Others may take a much tougher route and will just turn up. Okay, so again, if this were to happen, what you need to do is you need to check their ID, check they are who they say they are, ask them to explain why they are present and attending your premises. And for those of you that work in bigger organizations, there might be a hierarchy of who the local authority needs to deal with. So it may be an operations director, it may be the lettings manager, it may be a branch manager. But for smaller organizations, the likelihood is there may be a really, really small team. And some people find this kind of thing very challenging. So if you do have a person that you report to, that person, probably director, managing director, needs to be aware that the local authority is present, okay? Because this is immediate. They're going to want that information there and then, okay? It's not as though they're going to appear, you're not going to comply, they go away and come back. Okay, so they are going to want you to comply immediately. Why would they conduct a non-routine inspection with no warning? Because that's what this is called. Okay, so it's ad hoc. It happens on a Friday afternoon when everybody's hoping to go home. And what does it mean? The first point is that the local authority may feel that it's not reasonable or practical to give you advance warning, okay? And there are reasons behind that. The housing officers in question may feel that a warning defeats the object. And I'm going to use the word tipping off. They think if we contact you, if we write to you, if we give you advance warning, then you're going to try and put right everything that could be wrong. Okay, so they don't want to tip anybody off. They have reasonable and very serious point of view in that they feel that there is a breach taking place. So this is very, very important. Without a warrant, obviously, somebody needs to be on the premises. So if a member of staff is in the office on their own, then I would strongly advise that that member of staff asks the housing officer to wait, having identified who they are, and then they speak to a line manager and then go through the process with that line manager. Because, you know, potentially the housing officers, depending on what they're looking for, could be at the premises all day. We don't know. Okay, so it's the point here, the difference between the written notice and a non-routine inspection is that non-routine inspection relates to something very, very, very serious. Okay, so that's very important for you to bear in mind. So upon lawful entry, what can they do? I said that they can seize and detain documents where they feel that there is a suspicion or a breach, or they have knowledge of some of those elements of law. Okay, so it could be unlawful eviction, it could be related to disrepair under the Housing Act 2004, it could be related in the future to the Renters' Rights Act. So they need to have a reason. But in this case, it's going to be something really, really serious. Okay, and the elements of seriousness often relate to maintenance, serious disrepair, anything to do with an HMO or licensing. So they don't want to tip somebody off in advance. The documents can be collected and retained for up to 3 months, okay, unless these documents are required for ongoing legal proceedings. Now, this is very, very important. They can't take the originals away. They need copies. And so you can charge them for photocopies. That's very important. The likelihood is they will want access to electronic information. They may even want access to your computers, electronic devices. That kind of thing is really important. But some of our clients hold all their data centrally in a hub that is not local, so they may not be authorized to access that information. So those kinds of things are really important. And what we've done as part of our training sessions is we put together a 2-page document to give offices predominantly and landlords that we deal with an overview of what to expect and how this should be handled in-house by any member of staff. Okay, because remember, if on a non-routine inspection, firstly, you refuse access, and secondly, you refuse to comply, then the local authority can obtain a court order. Okay, and like I said, if they have reason, it won't be very difficult. So, as I said, copies of any documents produced may be taken. They may ask you for an explanation of what the documents are. That sounds very odd, because we're dealing with housing officers, but not every single housing officer is very experienced. Some don't have as much knowledge as others. They may need you to explain certain things to them, and that will be an expectation. Remember that they can...
just quickly interrupt, just in
Yes.
terms of
Yes.
from a Q&A perspective, just for all of those watching and listening to along, super informative so far already. So again,
Okay.
for those of you watching, in terms of the Q&A, the Q&A session is at the end. A few people have asked when are these questions going to be answered. A couple of points just off the back of it, I guess, is this session is going to be recorded, everybody. So just to make that very clear. From a Q&A perspective, you can upvote questions if you find that question interesting or think it should be asked. However, I would reiterate, this is a series of sessions about the Renters' Rights Act. So hopefully you can keep these questions about the local authority enforcement powers. We can get around to answering those questions at the end. So please continue to submit your questions. If you're interested in other people's questions and want that one to be answered, vote that question upwards, and when we hit that Q&A section, we'll go through as many of them as possible. So terribly sorry to interrupt, Susan.
No, that's okay.
Rather than somebody waiting at the end,
no,
that's
okay.
Thank you very much.
Gave me a chance to get a breath. So back to the documents. They may ask for an explanation of what the document relates to, of what the document is for, that kind of thing. Remember, especially for letting agents have systems, strong processes, audit trails, CRM systems. They may ask for access to that information. Okay, so that's really important. And then right at the very bottom is something is really, really key. I've already mentioned in terms of the request for information, where they tell you in writing what they require, and we do not want to breach GDPR or DPA or privacy or confidentiality. So if there's confidential material, for example, communication between the agent and their solicitors, the agent and their insurer, the agent who's dealing with something on behalf of the landlord and their lawyer, you cannot provide that information, okay, because there's a level of legal confidentiality. So be very careful. The premise here is if they're coming to your premises, don't rush. The likelihood is you might panic, but do not rush. You have to take your time, because they will tell you what they need. They will give you a list of information that they need and why, and you've got to be methodical. And if it means them coming back the next day, the likelihood is that they will. Remember, I said that this is relating to a very, very serious breach. Okay, so access to the seized documents. I've said that they can access the information. You should be keeping copies of any information that you provide, albeit whether the request is made in writing or there's a non-routine inspection. But I really do stress they will keep a list as well. They'll keep a list, they'll provide you with a receipt, they'll tell you what they've taken, and you should be doing the same. You should have a kind of checklist. And most, if not all of our clients who are letting agents have checklists beyond imagination. So this does form part of what the local authority needs to do, but also part of what you need to do in terms of your due diligence. Okay, because remember, if this were to happen, regardless of whether it relates to a non-routine inspection and a visit without warning, or a request for information in writing, non-compliance and penalties could follow. Okay, so this is not something that they'll just be doing just because they feel like it. Okay, this is something because they genuinely believe there is a breach. So that's very important. I mentioned earlier that if you are providing copies, the legislation states that the local authority will be required to pay reasonable costs for meeting these requests. And one of those examples is photocopying costs. Okay, so that's really, really important. So just based on the non-routine inspection, and these may be some of the questions that may be asked during the Q&A, but I just wanted to preempt this. Why could a non-routine inspection take place? For this, I really want to reiterate, it is without warning. It could be that the local authority has had a complaint or a grievance about a letting agent and their conduct in relation to a property that they manage that has come from a tenant. Okay, so it could be related to that. It could be that the local authority believe that the issue in question and breaches are not related to the letting agent, but that they relate to the landlord. Okay, so effectively they're gathering information on site in the premises of a letting agent, maybe to just exclude the letting agent. Okay, but I really, really want to stress on question 2, is a routine inspection more serious than a written request for information? Absolutely, definitely. Okay, and I did really, really stress that both are serious, both are an indicator that the local authority believes that there has been a breach, but for the local authority to attend premises or even the property itself has to be something very, very serious. Okay, and the likelihood for a non-routine inspection, somebody, and it could be a neighbour, it could be a disgruntled competitor of a letting agent, it could even be a landlord or a tenant who has put in a complaint in relation to the management of a particular property or properties. Okay, so it's very, very serious. What about the tenant? What about the residential premises? Now, obviously, if you manage your own properties and you don't use an agent for management, the local authority could attend the property. Could a tenant who's in situ refuse access for a non-routine inspection? And the answer to that question is yes, because generally we know that some tenants refuse access for lots of different reasons. In this case, the local authority would then obtain a court order to gain access. Okay, they couldn't force access. So that's very, very important. Could the local authority request information from a letting agent who does not manage the rental property? And obviously the answer to that question is yes, because potentially, as I said, letting agents deal with the front end, okay, from taking on the property, having been instructed by the landlord, to dealing with all the compliance up to and including the tenant being handed keys, and then the landlord takes over management. So the local authority could be investigating the pre-tenancy process, okay, the front end. So potentially, yes. Okay, so be very mindful that could possibly happen. Now, as David said, the last webinar that we did on behalf of or in conjunction with DPS talked about a whole range of things. And one of the things that we did discuss were penalties for non-compliance. Now, I've talked about the enforcement powers, and today is very much about the enforcement powers and penalties for non-compliance. Up until and including the 30th of April, any penalties in relation to breaches of legislation, the legislation that I showed you right at the very beginning of the webinar, will be under those pieces of legislation. Okay, so that's really, really important to bear in mind. From the 1st of May, the structure of civil penalties changes. And I call this slide, if I had to retitle it and not call it penalties for non-compliance, I would say this is not for the faint-hearted. Now, you may think that that's facetious or patronizing, or I don't put a great deal of importance on this. Probably of all the slides that we put together and all the elements of the Renters' Rights Act, collectively, this is the most important, okay? Because I, on a professional and a legal and a personal level, I like to know what the consequences are. The law is the law. Okay, you have to allow a tenant to request pets. You can't take rent in advance. You won't be able to serve a Section 21 from the 1st of May 2026, and so on and so on and so on. But what are the consequences if you do breach the Renters' Rights Act? So what the government have done is they've put in place 3 key elements. Okay, and this is why I say this is not for the faint-hearted. I want to know, as a landlord and as a letting agent and as a property professional, what could happen if I were in breach. So the first is an offence that could be relatively minor, but it's an offence still. Breach of renters' rights, my very first offence, and I could face a penalty of up to 7,000. Okay, so that's not great. Okay, hopefully I won't do it again. But then there are subsequent offences or more serious offences, up to 40,000. Okay, so again, not for the faint-hearted. And these could be a collection of offences. So, you know, we're racking up civil penalties, financial civil penalties, which is not good for business. But then on top of this, and this is really, really serious, and, you know, I work with a lot of different stakeholders, and we're all of the very much similar mindset that you need to protect your business. If you feel that you can deal with this one, then that's great. Personally, I would really be very, very, very upset to face a rent repayment order. A rent repayment order is what I call a tenant incentivized penalty. So the penalties of up to 7, up to 40,000 will be imposed by the local authority, and they will go back into the local authority to build probably their enforcement team and to put standards and structures and boundaries into place. Okay, so that's an incentive already for local authorities to enforce, because it's clear the money goes back into the local authority. But the rent repayment order is different. These exist currently, and the ones that I've dealt with generally relate to breach of HMO regulations. Okay, that's the most common that I've seen, but it's not limited to breach of HMO regs. It could be any type of licensing, it could be disrepair. The rent repayment order currently, as it stands, and this will be the legal position until the 30th of April 2026, is that the tenant can apply for up to 12 months of their rent to be paid back. Okay, so just so that we're clear, if the tenant's been living there 3 years and there's a breach, the maximum they can apply for is up to 12 months. Okay, and they currently have 12 months to make the application, and it's to the first tier tribunal. Okay, so that's really important. From the 1st of May, that rent repayment goes from 12 months to 24. Okay, so that is significant. That's huge for a landlord. Okay, and not something that anybody should relish or think, oh, it's never going to happen to me. Okay, so this is really, really important. The tenant, instead of having 12 months to make that application, will have 24. And I'm going to tell you something that is really, really important. And, you know, we have discussions with landlords, agents. Sometimes, you know, I will do work for tenants, but there is no conflict of interest anywhere. And it is very, very clear that the tenant must prove the breach. But I can tell you, if it's breach of HMO regs, if it's breach of maintenance, repair, the likelihood is that they will have that evidence. And the form, known as an RRO1, is not difficult to complete. It's very, very straightforward. I call this for the tenants, provided they've got the evidence, and they don't even need to go to the first tier tribunal with legal representation. They can do this themselves. Okay, it's an easy win. It's an easy win. Now, the landlord, if they find themselves on the receiving end of a rent repayment order, or the agent, because it could be either or, must take legal advice, must do an audit of whatever the tenant is claiming to check, you know, is this a reality? Really very, very important. And like I said, in the last 2 or 3 years, I've seen more and more and more of these. Okay, and You know, I've given you an example on screen that is not low, it's a very significant amount of rent, but it's 1,500 per calendar month times 24, and the tenant therefore could possibly claim back up to £36,000 of their 2 years of rent. Now, what we normally do on training sessions is we ask agents to give us their highest figure of rent monthly under an AST. And one of our clients yesterday gave the figure of 7,500. So you can do the calculation yourselves. As a landlord, personally, professionally, I would want to protect my business. Okay, and this is my starting point. And rather than be fearful of this, because this is not a knee-jerk reaction to think, oh my goodness, I'm going to face penalties, I'm going to face rent repayment orders. What you should be thinking before anything, or I'm going to sell, no, you should be thinking, is my property compliant? Is my business compliant? Is there anything in the background that I think could lead to this? Okay, and the obvious things are breach of HMO regulations, breach of selective licensing, breach of additional licensing, breach of maintenance, breach of repair, and so on. Okay, and people get very worried about this, but then some other landlords get very complacent. This is never going to happen to me. The tenants are not going to know. Why would they know? Well, if you don't have a HMO license, the local authority will enforce, and then they will write to the tenant, and therefore the tenant has all the information that they need. It's not difficult. People say to me, why? This is very unfair. And I have represented tenants at first tier tribunal, and I'm told in a very unpleasant way, how could you? My response to that is, why didn't the landlord comply in the first place? And some of the situations that I've dealt with for tenants have been very unpleasant. Okay, and generally is somebody who's the younger demographic, doesn't have the knowledge, doesn't have the experience, doesn't have the understanding that the landlord has a duty of care to make sure that the property is compliant, to make sure that all the safety elements are in place, to make sure that they've obtained an HMO license, and so it goes on. This should not be a worry for any landlord or any letting agent in England that does things by the book. This is not for them. This is about those landlords, those types of agents that just really do not care about their tenants. And there are a lot of those, hence the tenant incentivized penalty. Now, having gone through this process, I must make it very clear that the landlord has 28 days to appeal the penalties. Often, in a situation relating to a rent repayment order, the sensible thing would be to have a discussion with the tenant. Okay, I've been in situations where we've been about to go into a hearing and I've had a discussion with the person opposite, legal representative, and I've said, can we come to some sort of agreement? And we put together a settlement, both parties sign it, and we don't even go into the hearing. The judge accepts that everybody's happy and the hearing doesn't take place. But there is always room for manoeuvre. But I just want you to be aware that this can be very damaging to a landlord's business and also to a letting agent's business. Okay, so just make sure that you have a really good understanding of what the penalties are and what this could look like from the 1st of May. As I said, you can sleep soundly if you are a good landlord and you're a good letting agent. Okay, but remember, you know, I start to think about how can this work in relation to no win, no fee. This is a dream for no win, no fee. This is a dream for organisations that want to take landlords to task, and they act purely on behalf of tenants. So my parting thought on this slide is protect your business. Okay, be diligent, audit your business, make sure that everything is as it should be. Key takeaways. So I just want to bring together everything that we've discussed this afternoon. And I know this is a one-way discussion because I'm doing the talking. So review your paperwork. Local authorities, the likelihood, and this is really important, the likelihood is the majority of letting agents and landlords on this webinar are very good at what they do. Okay, but they're expecting you, the local authority is expecting you to fail. Don't fail. Make sure that you review your paperwork. Now is the time to review your paperwork because we are going through significant change, okay, which is only 7 weeks away, not that far. So start looking at your portfolio, check your tenancy agreements, check your safety certificates, deposit information. Think about maintenance and repair, how you deal with it. We're not even on to AWAB's law. That will come later in the year or early 2027. And people panic. And I fully understand why. But you need to have a process. This is why when you work alongside letting agents to the extent that I do, you know, I'm blown away by the way that they run their processes and their systems, like a well-oiled machine. That's what landlords should be doing if they self-manage. Okay, so check your repair maintenance history. Licenses, not just in London, but, you know, London is this kind of hotbed, effectively, of, I'm not going to say problems, but local authorities daily are thinking, shall we license a particular area or ward? And then lo and behold, 6 months later, they've licensed. So check what the local authority is doing. You can go to local authority forums. You can use the local authority website. Check whether they are going to license in a particular area. And that is specifically additional licensing and selective licensing. I have to say, those are the two elements of licensing that keep tripping people up, okay? Because people say, I didn't know. We all know that in law, ignorance is not a defense. You are meant to know. You are meant to have the duty of skill, okay? So this is where a lot of our clients are really useful for landlords. They provide them with that support. Inventory check-in, property visits, checkouts, worth their weight in gold, okay? We've been, and it's making me smile because, you know, I'm working with DPS, and DPS know this better than anyone. The more information you have, the better your case if it comes to the point where you need to deduct monies, okay? So keep your systems and your processes really strong. Rent statements, obviously, for landlords, very important, equally for agents that either offer a rent collection service or a fully managed service, is to make sure we know what's happening. Is the tenant paying rent? If the answer to that question is no, do we know why? Is it related to maintenance, disrepair? Is there a problem that we're not aware of? Make it your business to have that communication in place with a tenant. And do not think, oh, I can't ask them why they haven't paid their rent. You need to, okay? And you need to address those things. So potentially the local authority can ask for all of that and more. Landlords and letting agents. We work with predominantly letting agents, property managers. We have a tiny cohort of very big landlords. And then we've had the privilege over the last 12 months to be in front of our clients, i.e. landlords, which is very unusual for us. But because of these changes, now there is no better time you need to look at your portfolio. You need to look at your paperwork. You can conduct a regular audit, and I know letting agents do this day in, day out. They run off report after report after report. Okay, and that's what I like about the compliance systems. Have a compliance calendar, track the certificate expiry dates. We know just off the top of our head that the majority of certificates will have a start date and an end date. So HMOs, additional licensing, selective, every 5 years, unless there's something that needs to be done quicker. Gas safety every 12 months, EICRs every 5 years, EPCs every 10. We know all of this, so you should be tracking that information. Keep your records up to date. I'm a big stickler on this. For me, it's non-negotiable. I know people think that's a bit dictatorial, but it's about process. If there are gaps in your systems, you can't prove you did what you say you did. Okay, so that's really very important. Designate an individual within your company to receive and action council inquiries. Now, if it's a corporate entity, and we have, as I said, a handful of landlords that could be the equivalent of a corporate. They're very big. And then we have corporates that are letting agents, and they tend to have somebody who deals with either compliance and or operations, and it's generally them. In a smaller organization, have that discussion at your morning meetings, go through the enforcement side of things and say, if this were to happen, how would we deal with this? Okay, because I'm not saying it will happen, but it may, and you just need to be ready. Prepare templates for responding to information and these notices and these requests for information. You know, I can't give you examples of what I've seen because they're confidential and data protected, but I can see them in my mind, and they're very, very clear as to what the local authority wants. Go back to them in a similar format. Okay, tick off everything that they've asked you for, check that you've got it, put it all in date order, be methodical, make it easier for them to do their job, and possibly see that they're barking up the wrong tree, because that could be a possibility as well. So I'm never fearful of compliance. So I prefer to be ready for compliance. And the business, as in the private rented sector, sits heavily around landlords, all of you. Working alongside you, you have these people with a superpower, and their superpower is as letting agents. Okay, they have systems, processes, they run internal checks. That's what you are paying them for. You're paying them to make sure that you do not get caught out. Okay, so that is a very valuable relationship for you. And there we are. So my last slide is not very interesting. That's it, David.
Brilliant. Thank you, Susie.
So much information there to take in, for collating that, putting it together for everybody. I'm sure we've all learned something new today. I know I do every time I speak to you. From a Q&A perspective, I will just clarify, I know I sort of stopped halfway through that this is the first of 5 sessions we'll be doing with Susie. So if your question doesn't get answered today, it may be because it's just not relevant to the local authority enforcement powers. We want to keep it specific to this topic. The Generalised Renters' Rights Act webinar that we did, I'll ensure that we send a copy of that in the post-event email so everybody can see that overview. But let's get into it. Let's get into some of these Q&A questions. One that I am going to include, just because it's got so many votes, it isn't specific to today, but I'll ask the question. If a tenant's paid rent up front for 6 or 12 months, does that need to be refunded to them ready for the 1st of May?
No.
No.
That was easy. There's a lot. I just wanted to spell a rumour. There are lots of rumours on the 1st of May, you need to refund that money. It was a surprise that government said that you didn't. So no. So that's a good thing. Makes it easier.
Brilliant. Thank you very much. And the next question, where are we? We have got,
Where
can you find the document that needs to be sent to all tenants before May?
So it could be before May, but let's go with the 1st of May. And I know that we've got a session specifically on this. I'm not sure when that will happen. It will be the .gov.uk website. Now, there are 2 documents, in fact, that we should be interested in. The first one is known as the information sheet. This is a template. Please do not put your own version together through AI, I stress, with a very smiley face. But the government will issue that template. Alongside that is another document, which will be for new tenancies, and that's the written statement of information and terms. So keep your eyes open. Should be, they did say March 26. We are currently in March 26. So fingers crossed in the next couple of weeks.
There we go. A question in relation to gas safety certificates. Do you need to keep all of those gas safety certificates, or can you provide them to the council, or just the current one, all of them?
So one of the things that is really important, and then this is historical since as long as I can remember, over the last 20 years, but I think since 1998, is you keep all your gas safeties. There are 2 reasons for that, is to prove compliance. That's the first one. And the second one is if you go to court currently, and up to and including 31st of July, 2026, under accelerated possession, a judge wants to see all those certificates. So, yeah, and this is where our clients who are letting agents, and not just letting agents, landlords, they keep everything. Okay, so that's really, really important.
And I know there's a lot of information and dates there. Again, it's going to be on demand, so you can skip back and pause if you want a specific question answered. A question, can the local authority find both the landlord and the letting agent? Yeah,
definitely. One of the things that I didn't mention when I was talking about compliance, and I just want to reiterate that question, is that, yes, potentially both can be fined. But there's also an addition to this that relates to limited companies. Now, obviously, a lot of letting agents run limited companies, so therefore they sit under the Companies Act and have a really good understanding of what their liabilities are as directors. This applies to landlords who are limited companies. So since the changes in taxation, a lot of landlords decided that the most tax efficient way to deal with things was to put their properties into a limited company. That doesn't mean that they can escape prosecution or fines. So the directors can be held liable. Okay, and worst case scenario, struck off for up to 7 years. So that's really important and a really good question.
And a really important point. This one's come up a couple of times. What is defined as a business premise? So if I use my home as an office to run a rental business, are you saying they can enter? So I guess this has come up a few times, Susie, as sort of landlord saying, I work from home. My residence is where I run my operation. So can the local authority and those sort of powers that you said can enter, is that applicable?
So the first thing is a business premises is the place where you run your business. If the business is registered at your own home and you run, we do have some clients that work in this way, then potentially, if that's the registered address, that's where they'll attend. Okay, so that's really important. Some agents, clients, landlords may register their business address with their accountant. So, you know, wherever that business is registered, and the local authority will do their due diligence. If they need to find somebody, they'll find someone. So, yeah, potentially, yes.
So I guess regardless of location from that perspective, then it's, if that's what you've listed as your place of residence to carry out your activities, then just be mindful that is the place that they make.
It's that word activity. It's your rental business activity. And, you know, David's made another point. It could be that it's not on the high street. It could be a serviced office. So, yeah, potentially, yeah.
A question here. about sort of HMOs. With the withdrawal of Section 21 notices, if a landlord is operating a HMO, what can they do with a view to removing tenants when they're being uncooperative, disrespectful, unkind to other housemates? Those other housemates then want to move out. I know, again, apologies, this isn't specific to this topic we're covering today, but it's a question many are asking.
So I'll split that question up into two parts. The first part is the removal of a tenant, uncooperative, disrespectful, unkind. I'd kind of put all of that under antisocial behaviour, breach of contract. That would be grounds under Section 8. I'd probably go for ground 12. But remember, that's a discretionary ground, not necessarily something that is going to be easy to deal with if you then have to go to court and present that information to a judge who needs a lot of information and a lot of evidence. So it would be ground 12 under Section 8. The second part of that is if other housemates consider moving out, and this is something that I spent quite a long time on yesterday and have done over the last few weeks, is that tenants will be able to serve notice. This is really, really important. But if you imagine you have 5 tenants living in an HMO, all named on the same tenancy, and one of them potentially is not happy, they can serve notice, and that notice applies to everyone. So think about that very carefully, that when you do have tenants who may serve notice, joint and severally, from the 1st of May, do take legal advice, because it's changing things drastically. And, you know, this person might not be happy, and they might think, well, I'm not being treated well, so what I'm going to do is serve notice, and the rest of you can just figure it out. So, yeah, on a practical level, be mindful that that might happen.
And I know we'll probably touch on that a little bit more as we go through this series of webinars, so not necessarily specific to today now. One of the questions that did come up in terms of having to provide information to local authorities, a lot of questions about the tenancy agreement. So will that will have tenants' contact details, GDPR, that sort of information world. Will it be a responsibility that people will need to redact such details before they send them over?
Yeah, so landlord information is likely that they'll have that, but email addresses, I can see that Bavin has written email addresses, previous address, contact numbers, redact all of that information. Okay, because if they need contact with the tenant and the tenant is still in situ, they'll just write to them at the property. But yeah, be really careful. I'm a big advocate of GDPR. So yeah, redact, and if they ask you why, explain to them that. And you know, I would say that most local authorities are pretty good on GDPR and DPA.
And another one that's came up quite a few times here, in relation to the 7-day notice that was spoken about, and I know you've covered off already. Is that time frame too short? And those questions, but the question coming up quite often is, what if I'm on holiday? Is it, and another one, is it sent by post? So maybe I'll ask you both those questions. So how will it be sent?
Yeah, very good.
What happens if I'm not around in that 7-day period?
So if we think about how it could be sent, the likelihood, the ones that I've seen have been by post and by email. And the ones that I've seen have been sent to agents. I've not had anything come to us through any of our landlords that work with us. So that's 2 possibilities. I'm on holiday, it's summer, I'm away for 3 weeks, if only. Not going to happen with the Renters' Rights Act. But let's say that, you know, somebody who's the team member in charge of this is away, then other members of staff are going to have to say, you know, can we have an extension? You know, the worst thing is when you are up against a deadline and you decide the day before that final deadline that you're not going to make the deadline. So preempt it. If it's 7 days, I don't think 7 days is a lot of time. And the more onerous, the more challenging. So if you receive a letter that stipulates 7 days from the date of this letter or this email, Give it 24 hours, think about what you need to do, and ask for an extension.
So in that scenario, that's probably maybe a point that people won't get.
Yeah.
With that 7 days, you can ask for an extension with specific grounds for that extension, I guess, or
Yeah.
that this person's away or the info is not available.
Yeah.
Reach out. Don't wait until day 7.
No.
Don't turn up and say, on day 8, I can't provide it.
No. And I think, those of you that work in teams, you follow each other's calendars. You're all very strict about, holiday, annual leave and that kind of thing. And even if you are a sole landlord working alone and you've been away and you come back and you think, oh my goodness, I've received this letter, we'll contact them straight away. So I was away, my post didn't get picked up, and then explain. Do not leave it, because the last thing you need is them chasing you and then a court order. I'd rather avoid that.
Yeah, absolutely. A question here, again, this is another one that's come up a couple of times. You stated that a landlord with 3 properties was a rental business. What if a landlord only has 1 or 2 properties? So I guess the question we're asking here is there a number? Is there a cutoff that is defined as a rental business?
0 is the cutoff. 1 is a rental business.
Okay.
Because you're earning income from the property. So, and I just want to make it really clear that you could be a landlord with 1 property and an accidental landlord, for whatever reason that happened, or you can have 1,000 properties. It's still a rental business.
Mm-hmm. Absolutely. So looking at some of these other questions here now, I think a lot of them we've answered, which are in relation specifically to local authority. We've got a few here about rent in advance, which you've touched on already. Pets, we've got a session coming up about pets, which will cover all those lovely furry creatures. In relation to, there's another one in relation to GDPR here. So the question is, apologies for the delay, how do we protect GDPR in terms of documents being seized? And we spoke about somebody coming into your place of business and they might want to take photographs and documents. How do landlords agents protect GDPR, or where does that sit, I guess?
Yeah, no, not at all. I think that one of the things here is obviously, the difference between receiving a written notice and advance warning is better than when they just turn up, because it gives you time to get ready, to prepare, to look at what you're sending. You should apply those same rules to, the fact that it's a non-routine inspection. You've got to pull all of that information together. The housing officers are going to be maybe in 1s or 2s, who knows? And they're just going to have to wait, and then you're going to have to go through everything with a fine-tooth comb to make sure you're not in breach. And it could take more than one person to collate all of this information. And remember, one of you could be photocopying, the other one could be redacting, and then another person could be making a list of all the data that you're giving them. So do not rush. And I think we've never faced this before. This is brand new. Yeah. And I think one of the emotional reaction is panic or fear or what's going to happen. But, they're in your domain. Yes, they do have powers, but don't rush. If it takes all day to get through a bundle and they're going to have to come back the next day for you to finish off, then so be it. But you'll have to explain why. So do not give out information that you shouldn't be giving, because you don't want to be on the receiving end of then, possible penalty for breaching confidentiality.
Brilliant, thank you. A question here in terms of sort of registers databases. Will private landlords need to register with the local authority or centrally? So
this is we're not quite here yet. One of the things that we're doing with DPS and on other training sessions and events that we deal with is we're dealing with everything leading up to and including the 1st of May. So the database sits in phase 2, and that will be a national database, England only. The pilot for that will probably start in the Midlands at the tail end of this year, so end of 2026. All landlords will be required to register themselves and their properties. So the person that asked about what is a rental business, if you have 2 properties, you own 2, you may own them outright, you register your 2 rental properties. If you have 1,000, you register all 1,000. So the whole of England and every single property will be registered on that database. And the likelihood is it will be rolled out nationwide in 2027. So we've got some time, and that is going to be another big piece of work. But we've already prepped quite a lot of information in 2 sessions for DPS a bit later on in the year.
Yeah, absolutely. So in terms of today's session, with Q&A in relation to local authority enforcement powers, what I don't want to do, Susie, is ask you questions about topics that we're going to be covering in the future and spoil all the fun of learning more about the Renters' Rights Act. So what I will say to everybody joining today is a huge thank you for joining. A reminder that after each session is completed, they will be available to watch on demand. In relation to the overview session, we'll get that included in a post-event email. Keep an eye out for emails from the DPS about future sessions. Again, this is session 1 of 5 of these webinars. In order to sign up, you will sign up for each session individually for these. The content provided today, this doesn't belong to the DPS. This is a guest webinar. We're very fortunate to have Susie joining today to provide this. So any questions surrounding the Renters' Rights Act, I would probably say the DPS isn't your best bet to be asking the questions. If you have anything in relation to tenancy deposits, deposit deductions, adjudications, we've got some great webinars coming up directly ourselves. So if you'd like to know more about the Guild of Letting Agents Management, then please do visit their website, contact them via phone, via email to join their wonderful training courses that they do also. And you will also be able to go on the government website to find out more information on the Renters' Rights Act. So all that's left to say from me is a huge thank you to you, Susie, for joining today. And,
you're welcome.
And providing that huge bank of knowledge that's come across in all the future sessions. So I look forward to catching up with you soon at our future sessions.
Thank you. Thank you. Thank you, everyone.
Thanks, everyone. Take care.